Welcome to this episode of the Sangamon County Circuit Clerk Presents. I'm Betsy Moore. The following program is one in a series of programs on various topics of public interest that concern the Circuit Clerk's office, their various departments, and the issues they deal with. These programs are produced for your benefit in the hope that the information contained within will help you better understand the role and the scope of the Sangamon County Circuit Clerk's office.
Hello, my name is Nancy Martin, and I'm an attorney here in Springfield, Illinois with the firm of Graham & Graham. I've been practicing since March of 1986 with this firm in Springfield, and so I've had a bit of experience with the estate probate process, and that's what I've been asked to come and speak to you about today. In order to understand the probate process, there are some basic things you need to understand. One, there's a couple terms. Testate and intestate. Testate means that the decedent, or the person who died, had a will when they died. And of course we know not everybody has wills when they pass away, and so therefore their estate is referred to as intestate. The other thing that's important to understand is what probate means. For those who have a will, it is a legal binding, it is a legal document, perfectly executed. However, it doesn't have legal binding effect until it's admitted to probate. So, let me say it this way, and there are certain circumstances in when it may not need to be probated, hence you hear people talking about avoiding probate. So, first of all, when someone dies, you have to determine whether or not they have a will. Secondly, if they have a will, you need to decide whether or not it needs to be probated. All wills, regardless of whether they're probated, by law must be filed in the county where either the decedent died or where they own real estate. If they don't have real estate, if it's not convenient to if it's not convenient to put or to file the will in the county where they actually died, any county in the state of Illinois, assuming they died in Illinois, is appropriate for the will to be filed there. But there's really supposed to be some sort of connection with the decedent so that others will know where to file the estate. When there is no will, as I mentioned before, it's referred to as an intestate estate, and contrary to popular belief, the state does not get your money, but rather the statutes define and provide for who are the beneficiaries of the estate and what portion of the estate they'll receive. So if someone dies and they were married at the time of their death and they had no children, then their spouse would inherit the entire estate. If, however, they died being married and they had children, the children are entitled to half of their estate. However many children it is, they divide up the half, and the spouse receives the other half, which is a reason why even married couples ought to have wills, because a lot of times what they intend is for the other spouse to own whatever they had when they die, and not all their assets are necessarily jointly held. Also, another thing to point out is when you're talking about intestate, and all estates, but particularly it's important with this intestate estates, recently adopted was the Civil Union Act. And so for the probate law, if you have a civil union partner, that partner, wherever it says spouse in the probate code, that also means civil union partner. So in a case where you have two individuals, two adults who were joined into a civil union, that each of them will be treated as a spouse. So if there is no will, again, even if that person died and because they're not married but had a civil union in place, that other person, their partner, would in fact inherit everything, and none of the natural family would inherit anything. I mentioned earlier about not all estates needed to be probated, and for that there's a couple of things to look at. Again, first thing I do with clients after someone has passed away and the family or friends come to me is we identify what assets did the decedent have, because after all, that's what estates are all about, is what did the decedent own. We have to figure out what they owned and how they owned it, because this day and age, a lot of people have assets that are jointly held, and they hold them as joint tenants with right of survivorship, which means as soon as one tenant, one person dies, whether there's 4 joint tenants or 2 joint tenants, whoever the other joint tenants are that are living, that asset belongs to them. We're also seeing a lot of the payable on death accounts, or more commonly used with brokerage accounts, they refer to it as a transfer on death or a TOD provision. And again, that means that regardless of what's going on with the will, that automatically goes to the person who is named as the transfer on death beneficiary. And of course, there's still the traditional beneficiaries that we're all used to putting on, say, IRAs, life insurance policies, 401k plans, things of that nature. So, stepping back a second, let me also say that the probate estate is only going to control, the probate process, is only going to control assets that are owned solely by the deceased person, just in their name. No TODs, no PODs, no joint ownership, no beneficiary designations, because all of those things will go automatically to whoever is named on those designations, and it doesn't matter what you say in your will. You could have got ticked off with your entire family and wrote a will that says, I'm just going to leave everything to my favorite charity, but if your family members are the ones who you previously listed as beneficiaries, transfer on death made transfer on death designations for the family members, those things will not go to the charity because they have beneficiary designations. The other another thing that is commonly misunderstood is if you avoid probate, you avoid estate taxes. Not the case. Here's an instance, and there are other instances we won't go into today because this is supposed to be kind of an overview. As I said, I've been doing this since 1986, so I could be here for hours telling you stories, but I won't. But the estate, for purposes of estate taxes, means anything you owned when you died. It doesn't matter if it was jointly owned. It doesn't matter if it has a payable on death designation or transfer on death designation, whatever. It is includable, and then there's ways to have it not be taxable, but it's includable when you're figuring out, do I owe estate taxes? So just because someone died, had all their assets in a trust, the trust took the place of the will and said, you know, when I die, everything goes to my 2 children, divided up between them. Probate in that instance would not be necessary because it's not owned just by me. But on the other hand, it may be subject to estate tax. Now, also, as is fairly common knowledge, we have very high estate tax exemption amounts right now. So most of us won't be worrying about that. As we sit here today, the federal estate tax level is at $5 million, and the state was at $2.5 million and is moving gradually to become $4 million. When you're starting to talk about those kind of numbers, because there's all kinds of nuances about, well, first of all, how to prepare the estate tax return, second, whether or not you need to prepare one and file one, and third, what impact transferring assets, even if it means cashing in life insurance policies because you're the beneficiary or whatever, there could be things that could be done in order to reduce the amount of tax that might be due. Again, for those reasons, they're more complex than our discussion today, and I strongly recommend that you consult with an attorney because there may be some hidden problems there that you're not aware of. So, back to assuming that someone has died and all they have, and they do have assets that are just in their name when they passed away. If there is real estate's one of those assets, and or there is personal property. That can be tangible stuff, stuff you can touch and feel, cars, boats, antiques, jewelry, whatever, plus intangible personal property, bank accounts, brokerage accounts, savings bonds, you name it, whatever money instruments are out there. If the deceased person owns real estate and or has personal property that exceeds, when you add all of it together, it exceeds $100,000, then you must probate the estate, or at least the law says you must probate the estate. I'll get to a couple of exceptions later. Also, conversely, if you don't own real estate, the deceased person didn't own real estate, and they have less than $100,000 of that personal property. Again, not just one thing is worth less than $100,000, but you've got everything together is less than $100,000. There is a vehicle by which you can transfer that if the right conditions are met, called a small estate affidavit. It's a statutory form that's provided. A lot of the circuit clerks have them as part of their forms, and if not, you can certainly find them online. There are also a few institutions that have their own version of the small state affidavit, which you must use, such as the Illinois Secretary of State. It's basically the same form. It says, whoever's completing the affidavit, I'm so-and-so, such and such died on such and such a day. All that they owned when they died was A, B, and C. Oh, by the way, they either had a will, and here's who it provided are the beneficiaries, or no, they did not have a will, and oh, by the way, the heirs, the people who are to take, the spouse or the kids, and the percentages, they're the ones who should inherit these things. There are no unpaid bills, or at least there's no reason to think there won't be sufficient assets to pay the bills. The funeral expenses have been paid, and there's no fight, conflict, discrepancy about the heirship of the deceased person. If all those conditions are met, then you may use a small estate affidavit. The nice thing that I've recently learned about Illinois' small estate small estate process is that it doesn't involve the court at all. Yes, you do still have to file the will with the circuit clerk's office, and as one of the attachments to the small estate affidavit, you need to get a certified copy of the will, but that's it. Some of our neighboring states, Missouri, and I believe Iowa, or further away, Texas and Arizona, they actually do, even though you use the small estate process, they actually do require some involvement with the judicial system, and hence it's not as convenient. But I think what it does, if I understand the process, not practicing in those states, is that it streamlines the probate process a bit and makes it a little bit easier. That's the incentive to use it. Okay, so we might either be able to use the small estate affidavit, or we're going to have to probate it. Oh, let me back up a second. When you have real estate, and that's what is causing you to need to probate the estate, there are some times when probating it may not be necessary to simply get it to the spouse or to the children. If you have a group of people who get along, and if let's just say you have an attorney involved who understands how to move title from the real estate to some other individuals. It's an exception to the rule. It works in Sangamon County. I'm not going to say it'll work in every county in Illinois, but it's possible that with every rule there's an exception. But generally speaking, if you own real estate, you need to plan on probating the estate. And again, real estate just in the decedent's name, no joint owners. Also, just because you don't need to probate an estate because you don't have that real estate or your personal property is less than $100,000, sometimes it's a good idea to do it anyway. We've seen situations where we've probated it because there's creditor issues, untimely death of a spouse who had his own business and left a lot of debts, and he just happened to be in the construction business and just happened to die in the winter, none of which could have predicted, but had a lot of bills that were his company's, and we tried to shelter, or we did shelter, the wife's limited assets, the marital property, if you will, from the debts of his business. So sometimes, as I said, you do probate it even though maybe you didn't have to. It's kind of what I refer to as a decedent's bankruptcy, because you're really just getting rid of the debts of the decedent so that the creditors aren't hounding the family who's left behind. Also, the probate process shortens the statute of limitations for creditors. Also, if there's a fight with heirship issues, you don't know who all the children are, there may be a missing decedent, you're not sure, the probate process consolidates all of those to a 6-month period. Otherwise, creditors have 2 years after someone has died to come forward and say, hey, you owe me money. And that includes things like taxing bodies, Illinois Department of Revenue, IRS. So if you're trying to make sure that you've got everything done for this deceased person and you don't want to hang around and worry about in 2 years, are there going to be some surprises, it may be a reason to probate. Again, I know I'm an attorney and people think I'm biased, but you can work through a lot of these problems to figure out, is this applied to you or not, by speaking with the attorney. And the other thing is, it's never too late to probate an estate. I had a spouse who came to me not long ago, well, actually a little while ago, when her husband died, and assured me everything was joint, no reason to probate his will. We went ahead and filed the will like we were supposed to. Oh, there might have been a little something or other. We used a small estate affidavit like for a savings bond that was only worth $25 or something. But generally speaking, everything was fine. 2 or 3 years after the spouse died, suddenly I get this frantic call. Turns out that her name was never put on the title to their home that they had owned for many years. And so she was concerned about, oh my gosh, what do I do? So long story short, this is one of those exceptions where we were able to simply have her children quitclaim their interest to her with the house. We avoided needing to probate it, but had the children not cooperated, we could have easily probated the estate. Didn't matter that it was 3 or 4 years after he passed away, and simply follow the terms of the will then that says everything I own goes to my spouse, hence getting the title to the house in her name. Okay, let's move along with assuming we're going to probate. There are some basic forms to open up the estate. You've got a petition. Doesn't matter if it's testate or intestate. You still have to ask for this estate to be open. If it's testate, it's a much quicker process. You, again, explain in the form who you are, that there was a will, here's what it provided, and here's who is asked to be the executor. If it is a legally conforming to Illinois law document, then basically once you've got that petition completed and a couple other forms, you can go into court next day, have the executor appointed. If, however, there is no will, then unless all of the eligible beneficiaries or what's the word I want to say? Beneficiaries of the estate's a simple enough word. If those that are entitled, again by law, and you'd have to know what the law is to know who's qualified to appoint a administrator in an intestate estate, because administrators are basically the executor of an intestate estate. Executors are the legal representative for an estate where there is a will. But anyway, if you're talking about petition for letters of administration, then in that case, it may take 30 days to have someone appointed to be able to get things going, for the estate to officially be open, unless you can get the heirs that need to sign a relinquishment of their right and a consent to the person who's being nominated. There is supervised versus independent. Again, doesn't matter which kind of an estate, testate or intestate. Supervised just means that there are a few things that the court needs to give approval for. Also, inventories must need to be filed with the court. A detailed accounting needs to be filed with the court. Independent gives the executor or the administrator a little more freedom to just do what they need to do to get the job done. And they don't have to disclose necessarily all the particulars of the estate, all the dollars and cents that belong to the deceased person, and who is receiving, for the beneficiaries of the estate. That information would not need to be filed with the court, thereby making it public record in an independent administration. So again, a couple things to think about, and with some advice would kind of direct you where to go there. You've got an affidavit of heirship that needs to be prepared, filed, and similarly the court signs an order declaring the heirship. And this becomes important because all heirs have the right to contest a will, and of course if there is no will, then they have the right to argue about who's supposed to get what. Oath and bond, simply your written promise to do what you're supposed to do as administrator or executor and not abscond with any of the funds. It may require sureties, which are people who are guaranteeing that you will do what you're supposed to do. Most times a validly traditional will that's been prepared, it usually waives the sureties, but not always, so sometimes that might be required. And then finally there's the order that says, okay, here's who the administrator is going to be, here's who the executor is going to be, and the clerk's going to issue letters of office, letters testamentary or letters of administration, that are what the executor administrator would use to go to the bank, to go to wherever, Secretary of State's office, to prove that they are in fact the executor or the administrator. From time to time, somebody who you're giving these letters to may say, you know what, they're kind of old. They're more than 3 months old. They're more than 6 months old. We want you to get us more recent letters. You can go to the circuit clerk's office and get updated ones. Again, just showing that the court hasn't revoked the representative's authority to do what they're doing. Also, while it's not part of the probate process, it is getting to be, well, it is necessary if you're dealing with an estate. You're going to need to get an employer identification number from the IRS because there is undoubtedly something out there that there's going to need to be a replacement for the Social Security number. The Social Security number was fine while the person who owned it was alive, bank accounts, whatever you owned. But when you're transferring it into the estate's name, can no longer use the Social Security number, now need to use an EIN, so you will need to get one of those. There will be notices that have to be given. If you're talking about a probate estate, there's a notice you have to give to the heirs and legatees, letting them know, oh, by the way, here's what has happened. We've opened up this estate. Here's who the executor is. You have 6 months in which you can contest it, both to those who are named in the will and also the family members, the heirs, the blood relation, who may have been left out, or if there is no will, just plain the heirs. Again, it's advising them of the rights of what they can or can't do. And if you've used what I referred to as the independent administration a little while ago, there are notices that have to be given to everyone, any interested party in the estate, letting them know that how the independent administration can be revoked, so that you have to be supervised by the court, what it means, etc., etc. Then you've got the estate open. Now, fairly shortly after opening it, because you want to get that 6 months going, you file a claim notice in a local, newspaper that sets forth, oh, by the way, if you're a creditor out there for this deceased person, you have 6 months. 6 months runs from the date of first publication until, well, it just begins running from the date of first publication. It's provided in the claim notice, so typically, I know when I prepare them, I just figure the newspaper will start running it at least a week from when I give it to them. So I just add a week on to 6 months from when I send the notice to the newspaper. There's also a notice to creditors that has to be given. It used to be that just the claim notice was enough, but quite a few years ago, because there was some people taking advantage of creditors who didn't bother to file a claim notice in the estate, they were trying to duck having to pay it for that reason. So if there are reasonably known creditors, those who people dealt with in the last couple of years of their lives, they'd be a reasonably known creditor. You also, in addition to putting the claim notice in the paper, you also need to give them notice of the claim date and the fact that there's an estate. That's all done fairly within, well, the claim notice is done right after you open the estate. The notice to creditors gets done when you have a better feeling of who the creditors might be, so 2 months, 3 months into the probate process. An inventory, as I said, may or may not need to be filed, but you always have to prepare an inventory, and you have to give it to the interested parties. Again, if there's a will, you're really talking about the beneficiaries, unless there's a will contest kind of a thing happening. And if there are creditors who may not get paid, they need to get a copy of the inventory too. But bottom line is, always have to prepare and provide an inventory. It's just a question of whether or not it needs to be filed with the court, depending on if it's supervised or independent administration. Real estate, again, that might be the reason why you're there in probate. If there's a will, and if it gives the executor the authority to sell that real estate, no problem. Executor or administrator, well, not administrator, but the executor does it and moves on. If there is no power of sale in that will, or you're talking about letters of administration, there was no will, then you actually need to go to the court to get authority to sell it. Backing up a step. If it's independent administration, that's one of those exceptions to the rule where then you don't have to ask the court for permission to sell the real estate at these terms to this person, et cetera, et cetera. But just be mindful that when you go to sell real estate, unlike other business of an administrator or an executor, it may require you to get court authority to do that. we're going to assume that we've gone through, it's been 6 months, maybe 9 months, depending on how long it took for those health insurance bills, or, health insurance claims to be processed, Medicare, sell the real estate, etc. So it looks like all the business is done. You've collected the assets, you've paid the debts, or you now know there's no more money and you have more debts than you can pay. So you're ready to wind up the estate. The first thing to start with is preparing the final account. That is generally, well, let's put it this way, there's always going to be an itemized final account. It's going to explain all the money that was received by the executor or administrator and how that money was paid out and how that administrator or executor proposes to distribute what's left. If it is supervised administration, then that final account gets filed in the court. If it's independent administration, that itemized report is only given to the interested party. But you still have to file kind of a summary style final account that says, yes, I've done everything I was supposed to. There weren't any creditors, I paid the income taxes, I paid the bills, et cetera, et cetera. It's just kind of what I call a summary style. But then that can be filed in the court. There have been instances where we've dealt with widows or widowers who received significant assets. And so we didn't necessarily want that to be in the public file where anybody could find out about that money. So if we had supervised administration, that was a good way to not have to disclose all of that, those particulars. You need to make sure that the final income tax return for the decedent's been filed, and it may be necessary to file a fiduciary income tax return. That's the income tax return for the estate. And if it's the final year of distribution and there is more income than deductible expenses, because again, you have to know what, for that income tax return, what expenses are deductible, it may be possible in that final, or may be required in that final year to pass it through to the beneficiary. Again, there's income tax reasons that that's better than having the estate pay it. Talk to your accountant or CPA or even your lawyer who prepares them. So, assuming we got all the taxes taken care of, assuming we got the final account all together, we've given notice to the beneficiaries of the estate, or we've gotten their consents. We've said, oh, by the way, here's what we have, and would you please sign this consent to it? Because then you can go in to the court, and the court says, all right, you've done your job. All you have left to do is distribute the money. So the court would sign what they call an order of discharge. It basically approves that final account and the final distributions provided in it. It also says, okay, executor, you're done with your job once you've distributed all the money. And so I'm going to discharge you from any more responsibilities, and I'm proving everything you've done up till this point. And oh, by the way, that oath and bond you filed early on, I'm going to go ahead and cancel that as well. And I'm telling the circuit clerk to officially close the estate. Huge, quick summary of all that's involved in the probate process, but that's how it is. I'm running out of time, so as I said, I could be here for hours. You don't want that. But hopefully this has helped kind of give you the ins and outs and a better understanding of what the probate process is about and whether or not you need to actually engage in the probate process, because more and more people are putting their assets in things that are designed to avoid probate. Thank you.
Thank you for watching this episode of Sangamon County Circuit Clerk Presents. These programs are produced for your benefit, to help you in your interaction with the court system. They're accessible on the Circuit Clerk's website and YouTube channel, as well as the City of Springfield's Public Access Channel 4. I'm Betsy Moore.